Right. So we were looking at the common law controls, and we looked at the incorporation by signature, and today we're going to look at incorporation by reasonable notice. Now, incorporation by signature uh, is applicable to which kind of documents? Written and signed documents, right? And what do you think about incorporation by reasonable notice?
It's more like in case of signed words, right? When you don't sign it,
Okay, so we are talking about, so remember this, we are talking about two types of two documents. One set of document is written and signed, and one is written and not written and unsigned. Okay, so in case of written and signed, incorporation by signature is fine. But whenever we are talking about written and unsigned documents, because there is no signature there, what is the way of giving the notice? The notice is by, it will have to be a reasonable way of giving the notice. Okay, putting the signature means you have the notice.
Yeah.
But when you do not put any signature, then how do you determine that whether you had a notice or not? Okay, right. Please do that. So the heading is incorporation by reasonable notice. If a contract is concluded,
Sir, can you wait for
if is concluded and the document which is used has not been signed, then reasonable notice must be given for incorporating the exclusion clause full stop. There are few requirements which must be taken into consideration for incorporation by notice. Incorporation by notice. Number one, the written and signed document must be of contractual nature. Number two, the degree of notice.
the written and signed document?
Sorry, written and unsigned document. Unsigned document must be of contractual nature. Number two, The degree of the notice.
Degree.
And number 3, the adequacy. Sorry, not the adequacy. Number 3, the effect of the notice. Okay. In the case of Chapelton versus Barry, no, you go. In the case of Chapelton versus Barry UDC, the plaintiff was given a ticket on hiring a deck chair. A deck chair. You know what is deck chair? Long deck chairs, the beaches and next to the swimming pool. He did not read the ticket, which stated.
Ticket on hiring a deck chair.
Full stop. Yeah. He did not read the ticket. Which stated that the council would not be liable for any damage or injuries suffered to the hirer while using the chair. Suffered to the hirer while using the chair. The plaintiff was injured due to a defect in the chair. Good stop. The court held that the chair. Full stop. The court held that the ticket was not a contractual document, but a mere voucher or receipt.
Voucher?
Or receipt. RECEIPT, receipt. But a mere voucher or receipt. MERE. Which cannot be regarded as a document therefore the exemption clause was not properly incorporated. Exemption clause was not properly incorporated.
It's in favor of the higher.
Read it again. Read the facts. What we are trying to do.
If the exclusion clause was not properly incorporated, so the one that chair can say he's not.
Protected.
Yeah, so it's in favor of the one who is hired.
Yes.
Because corporation now will he cannot exclude liability.
You get the facts?
Sir, I do not understand what you meant by the degree of the
Here or the next one?
here, like the degree of the requirements.
I'm going there. See, the first point, if you're talking about incorporation minorities, first thing that you have to fulfill is that the document must be a contractual document. A ticket is not regarded as a contractual document, it is a mere receipt. I paid you money, the ticket means that it is the receipt of the receipt of the payment. When you carry the ticket in your pocket, why do you carry it in your pocket? Because because someone may come and inspect whether you paid it. Say revenue collecting officer may come and check whether you paid for it, and you show that this look I have the receipt for payment. That's what the ticket is. Okay, so putting a clause in a ticket does not make the clause to be incorporated as part of the contract. That is what he said.
You might not even read
Are you clear? Okay. Even if you read it, what if you read it? Okay. According to Shackleton versus Berry, even if you read it, even if this person read it, it does not necessarily mean that it has been properly incorporated, because the ticket is not a contractual document. It is a mere receipt of the that is what quotes it. Are you clear? Okay. Okay. Go to the next paragraph. Our second one is, what is the second point?
the degree of
The degree of the notice.
Oh,
Okay. The principle about the degree of reasonableness of incorporation. Reasonableness of incorporation can be found in the case of Parker versus Southeastern Railway. In this case, the claimant left his bag in a station cloakroom. Station cloakroom, C-L-O-A-K, cloakroom. And he paid the fee for the cloakroom and got a ticket for that. On the back of the ticket, there was a clause limiting the liability of the company for the loss of property left with them. Left with them. The bag was lost from the cloakroom. And it was worth more than the value. It was worth more than the value mentioned on the ticket. The court held that a party could be deemed to have had reasonable notice, if they knew of the clause. If they knew of the clause, or if reasonable steps were taken to bring the clause to their notice. Full stop. The court clarified that time of the notice and form of the notice are also important factors here. Are important factors. In the case of Thornton versus Shoe Lane Parking,
So this is applicable for number 3.
no. What do you? In the case of Thornton versus Shoe Lane Parking, Mr. Thornton bought a ticket from a machine and parked his car. He had an accident at the car park. And he claimed damages. The ticket stated that parking was subject to conditions displayed on the premises. Conditions displayed on the premises. And various notices in the car park stated that the company did not accept responsibility for damages or personal injury. The defendants argued that the defendants, the owners, argued that they were exempted from the liability. Exempted from the liability. EXEMPTED, exempted from liability. The court held that the the terms displayed at the car park were not part of the contract because the claimant noticed it after the contract. Okay. Okay. So see, all these things will have to be taken into consideration. Number two, the next para. Yeah. What was the third point?
The effect of the notice.
Yeah. There are cases which suggests that the notice given to exempt liability must be an effective one, especially if there is a possibility that the users may have various forms of disability. What if someone can't read? What do you think? Printing it reasonably big, is it good enough? Printing it in big letters before you enter into the car park, is it good enough? What do you have to do? You probably have to say it. You have to have say public announcement, like things like that. Well, they sign language. They use sign languages. You know, so it must be the effect of the steps means that it will have to be given in some way, so that it can reach everyone. You know, anyone who knows that yes, when there is an exception clause or there is a limiting clause. Are we clear? Okay, good. Next, let's move to the next case. Sorry, the problem is when we were talking about the incorporation by a previous course of dealing. Okay. Heading previous course of dealing. Incorporation by previous course of dealing. Yeah.
Incorporation by previous course of
dealing. Yes. If two parties have previously made a series of contracts, previous course of dealing. Yes. If two parties have previously made a series of contracts between them, and those contracts contained an exemption clause, and those contracts contained an exemption clause, then that clause may also apply to a subsequent transaction even if the usual steps to incorporate the clause have not been taken. the clause have not been taken. You got that?
Yes, sir. Sparling.
Yeah. The case is Sparling versus Bradshaw. Okay. So where you see, if you have been doing business,
Case is
yeah. If we have been doing business for a long time, if we have been doing business for a long time, then you know, yeah. Even if the proper steps have not been taken.
Sparling versus Bradshaw. Ladies and gentlemen, presenting. I like the feature. What am I supposed to understand from all this? What am I supposed to understand from all this? I know.
So we clear so far. So if we have series of things we do over the years, and we have a new thing, then
We don't need to incorporate.
Okay. Because you have done it in the past. Even if it is not done, we take it that this is also part of the same kind of.
You express it.
Yeah. Okay. Right. Now, so we know about incorporation. The next thing is the interpretation of exemption clause.
Yeah.
Okay. So heading is interpreting exemption clauses. Now, you see, very simple thing. Think about the nature of the exclusion clause. What do you do? Why do you use the exclusion clause?
Try to get rid of liability.
You can try to get rid of the liability, right? Now, in contract, what type of language you should use?
Formal.
Yeah, I understand formal,
Easy language.
but is it something where it has got clear meaning or it has got unfair meaning?
Clear.
Where it's clear, it is clear meaning. Okay, so in any way, in any contract, in all the clauses, you should use clear and unambiguous language. Okay, and it is more important that you do that, especially when it is an exclusion clause. Because by an exclusion clause, what are you trying to do? You are staying in the contract, but at the same time you are saying, sorry, I don't take liability for it. So it is more important, even more important, that for that particular clause, what kind of language you use? Clear or unclear? Clear language should be used. Okay, so when it comes to the point of interpretation of language used in the exclusion clause, then that language must be clear and unambiguous. And when it comes to the point of interpretation, What the court will do? The court will not try to look at any other meaning but the strictest of meanings. So it is more like a literal interpretation.
এটা মানে কি কোর্ট কিভাবে ইন্টারপ্রেট করবে না ক্লজ?
Yeah. Say between you and me there's a dispute.
Yeah.
And I have and there's an exclusion clause. And court now needs to interpret the language of the some from that exclusion clause. What the court will do?
একই জিনিসটাই হচ্ছে না।
Yeah, what the court will do? The court will actually interpret it at its strict term. Okay, it will not say, okay, fine, here is a word, if we apply it liberally, it may also cover that. But if we do it strictly, then it would only mean this. If we have two choices, which one court will do? The court will go for the strict interpretation, not the liberal interpretation.
Sir, আমরা বুঝলাম যে ইন্টারপ্রেটিং এক্সাম্পশন ক্লজ মিন্স যে লায়াবিলিটি এক্সক্লুড করতে চাচ্ছে ওইটাই হইছে। Like I am trying to exclude liabilities for any damages that happens to your car, and that is what happened.
Yes, that's what I'm saying. Yeah, they will just go for the strict meaning. Okay, let's look at some examples right now. The court will examine whether the clause in question actually covers the breach that has occurred. That means the interpretation of the language. That means the interpretation of language shall be done strictly. In doing so, the court applies the contra proferentum rule. That means TM, PROFERENTEM, TEM, proferentum. That means where the words of an exemption clause are ambiguous, comma, they will be interpreted in the way least favorable to the party relying on them. Since the parties seeking to exempt themselves from liability will use unclear and ambiguous language. Unclear and ambiguous language in order to conceal their purpose.
Sir, is there an example?
Yeah. Take this one. Middleton versus Wiggins.
Yes, yes.
Yeah, name of the case. The claimant owned a landfill site. What is landfill site?
Landfill site.
Landfill site.
Right.
It's like landscape or something.
Landfill site means it's a piece of land where all the waste is disposed. It's called landfill site. You allowed the government to dump all the waste. FIW, landfill.
FILTH.
No, landfill, FIW.
Sir, can you repeat it?
The claimant owned a landfill site. Full stop. The rotting of the waste the rotting of the waste produced gases.
The government can pay for it.
The rotting of the waste produced gases which caused an explosion and destroyed a house nearby. They paid damages to the homeowner and claimed this expense from their insurers.
And
Claimed this expense from their insurers.
the insurance.
Yeah. The insurance company
Claim an insurance on the insurance.
claimed the expense from their insurers. Okay. The insurance company relied on an exclusion clause in the insurance policy
Insurance company. Relied on, sir.
on an exclusion clause
In the
which was for exclusion of liability for loss arising from the disposal of waste material.
Loss arising from the disposal of waste.
Of waste material. The Court of Appeal rejected, not refused, rejected the argument that this exclusion clause is sufficient to exclude liability of the insurance company,
Is sufficient.
to exclude liability of the insurance company, and interpreted the clause strictly
Interpreted.
the strictly stating that the accident had not occurred from the disposal of the waste.
Property की double R.
Yes, occurred from the disposal of the waste. But from the unforeseen escape of the gas. From the unforeseen escape of the gas. Resulting from the process of decomposition.
Resulted.
Resulting from the process of decomposition.
From the process of decomposition.
Process of
Decomposition. Okay. What did the court do here? What
Favored the one who suffered the loss.
So what did the court say?
It's not
Court said that you were
unfair.
exempting liability from process of disposal of waste.
Damages caused by
You can't say that the damage was caused indirectly by process of decomposition. Okay, if you want to say that you are covered from this thing, you have to say it specifically. You just can't say that, well, from there we can draw inference that it caused that. You can't draw inferences. If you want to exempt liability, you have to clearly mention it.
You can't say it's the same situation.
Yeah, you can't just say that, well, we had exemption of liability for disposal of waste. The disposal of waste has caused the gas has caused the explosion. Therefore, the explosion was caused by disposal of waste. You can't say that, you can't, draw that inference line. Okay, if you want to exempt liability, you have to say disposal of waste, any gas caused, and it, causing accident to any houses or any other property nearby. You have to, exactly. You have to be very specific. Otherwise, the interpretation will limit to the damages caused. That's it. Very simple. Are we clear? All right. So in our next class, we'll go through what we'll do. We'll look at the Unfair Contract Terms Act, the statute. All right. Thank you, guys.
Cool.